Special Magistrate Code Enforcement meeting of the City of St. Pete Beach to order for Monday, September 8th, 2025. Excuse me. Hello, my name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach, and I do not represent the city here today. I also do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comments related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first. The respondent will then be given an opportunity to refute the city's allegations. While formal rules of evidence do not apply to this proceeding, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy, so please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and under some circumstances to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not recorded by the compliance deadline if one is provided. If you wish to present any evidence today, please sign in at the podium before you speak, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. Anyone wishing to speak today, if you could please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So sworn. All right, are there any changes to the agenda here today?
Good morning, Madam Special Magistrate Pete Dewar, on behalf of the City of St. Pete Beach Code Enforcement, request to have case number 2025-0185 continued to October 6, 2025, please.
0185.
2025-0185, City of St. Pete Beach, Robert versus Robert Ruhlman.
Right, yeah, okay, and it's not presently on the agenda.
Oh, ma'am.
Yes, that case will be continued until October, and I will get a written order to that effect.
Very good, I appreciate it. Thank you, ma'am. And that's it for changes to the agenda.
Okay, then moving on to the first case, which is case number 2025-0067, City of St. Pete Beach versus Lake Merrick Partners, LLC.
Good morning, Special Magistrate. Ayaka Ruktashel, City of St. Pete Beach Code Enforcement. This is a continuation of the Fresh Development LLC fencing, unpermitted fencing. Your last order extended, gave them 30-day compliance to reach by August 15th, and the permit was applied for and is in review, was actually approved on August 29th. So now they are compliant.
Okay, so they were compliant as of August 29th?
Yes.
Okay, which came after the August 15th deadline.
Hang on. Excuse me. Wrong case.
No worries. No worries.
All right, so Lake Merritt Partners, yes. On 8/25, I left a voice message with the owner because their intention was to repair and demo the permit. Your order gave them a 30-day extension to 8/15, and as of this morning, there has been no permit applied for.
So no permit, and the property has not otherwise been cleaned up, is that correct?
Correct. So the city is asking for $250 in fines from 8/16. Plus administrative costs of $330.
Okay, have you had any opportunity to speak to the property owner?
No, I left the voice message and no response
And what day did you leave the voicemail, do you recall?
on 8/25.
On 8/25, okay. Thank you very much. Anyone here on behalf of Lake Merritt Partners LLC? Anyone here on behalf of Lake Merritt Partners LLC, 636 Corey Avenue? Okay, seeing no one. All right, I will find that the property is still in violation and in violation of my final administrative order. I am going to assess a fine of $250 per day, starting on 8/16/2025, to continue until the property comes into compliance. Is the city also requesting administrative costs and recording fees? How much are the administrative costs?
$330.
Okay, I am also going to go ahead and assess $330 in administrative costs of the city, plus any necessary recording fees to effect a lien if necessary. And I will get an order out to that effect. All right, moving on to 3B, case number 20250231, City of St. Pete Beach versus Fresh Development LLC.
Right, so this is the IACA Rec Shell, Code Enforcement, City of St. Pete Beach. This was an order for an unpermitted fence. You gave them an extension until August 15th for compliance. They have applied, and it was approved on August 29th.
Okay, so this one was, the permit for the fence was approved on August 29th. Is the city seeking any fines or fees?
Yes, so $250 from 8/16 until the permit approval date of 8/29, plus $330 in administrative costs.
Okay. All right, anyone here on behalf of Fresh Development LLC? Have you had any chance to speak with the property owner at all?
No.
Okay. One last time, anyone here on behalf of Fresh Development LLC, 6800 Sunset Way? All right, seeing no one, I will go ahead and find that the property is in compliance as of 8/29/2025. I am going to assess a $250 day fine from 8/16/2025 until 8/29/2025, as well as $330 in the reasonable administrative costs of the city. Moving on to agenda item 3C, case number 20250010, City of St. Pete Beach versus the Hagen Trust.
Yes, so IACA Rec Shell, City of St. Pete Beach Code Enforcement. This case involved overgrown vegetation and debris on the property. It was owned by the Hagen Trust. Your last compliance date gave a 30-day extension for them to come into order by 8/15. However, the property sold on 8/12 to a gentleman called Johnny Creamer, All Over Solutions. And can I have the overhead, please? He did make an effort to clean up the overgrown vegetation. However, there is still debris on the outside of the property that remains as of yesterday. And he had signed a hold harmless agreement when he purchased the property, knowing that there was an outstanding code enforcement case against this. So what I'd like to do is close out this case and only seek administrative costs against the previous owners, and a new case has been filed with the new owner. I was hoping that he would be here today. Mr. Demus here. So if he'd like to explain his intention with that property.
I don't have a code case where he's the owner before us today, so unfortunately, anything that it comes from him, I can't consider for this present case.
Okay, because he just assumes he'll assume the cost of that administrative fee. Because based on this hold harmless that he'd signed.
Okay, well, I mean, obviously he's here, so if you'd like to speak, I can certainly take any consideration that you have.
Yeah, I can just let you know what we have going on.
Yeah, if you'll come up and please just state your name for the record, and then go ahead and you can.
My name is John Creamer. I'm the owner of All Over Solutions LLC as of 2016.
Okay, and so you understand that there was a code case on the property, you were subject to it upon purchase?
Yeah.
And the city is looking to just close out that code case and potentially open a new one until the property is cleaned up, but it is seeking $330 of administrative costs
Understood.
from the previous owner, which I am understanding you are assuming.
Yep, we do
Okay.
it all the time and then get them into compliance and do whatever we do. So I purchased the property August 12th. August 15th, I immediately sent over a company to clean up all the vegetation and overgrowth, which was done. They were actually supposed to take the trash and debris on the front porch, which has a few minor items. They didn't. There was a little miscommunication there because they're a tree company. He said, we don't take trash.
Sure.
They didn't want to mix debris.
Sure.
So I was on that right away, 3 days after closing. I did do that. I didn't apply for a permit because we have to have an NOC recorded before we can apply for the permit with you guys through the county. When I did apply for the NOC, the county kicked it back because I didn't put manager next to my Oliver Solutions. So we did get that back. All American Contractors is applying for that. As of this morning, we got the corrected NOC applied for through Pinellas County, and we will be, I would assume we should get that back today or tomorrow. We will be applying for a demo permit for the home. We'll be demoing it, applying for new construction with obviously all the correct documents. We'll be building new construction there.
Okay.
And making the neighborhood a lot nicer with that.
Okay, well, that all sounds good to me. Mr. Kramer, just make sure that we have your contact information, because I am going to send an order. That way you at least
Yep,
have
of
it.
course.
It's just going to include that you're going to assume the 300.
And then once I do, I'm not sure if you can answer this, but once I do apply for that demo permit, that's kind of giving you guys that assurance that I'm moving forward with that. And obviously, the reason why I haven't cleaned up the trash is because there's quite a bit of trash in the backyard. Obviously, you can't see it from the front, but the guy who's demoing the house has also taken all that at one time.
Okay, yeah, that's something you definitely want to keep in touch with the city
Okay.
about, just to make sure, because I would hate for them to open a code case when you're trying to actively work on the property.
Thank you so much.
Yep. All right, thank you, Mr. Kramer. I appreciate that. All right, then I will consider this case closed, and for this property owner, I will consider the property into compliance, but I am going to assess the $330 in reasonable administrative costs of the city, which the testimony here today will be assumed by the new property owner. That will be included in my order. Okay, moving on to case number 3-4, case number 202-50211, City of St. Pete Beach versus Starlight Tower Incorporated.
So, Iaka Ruckshell, City of St. Pete Beach Code Enforcement. This is the Starlight Tower, unpermitted work done for a garage wall. Your order gave them 30 days to meet compliance by August 15th. Their permit was issued and approved on August 6th. So the city is seeking no fines. However, we would like $330 in administrative costs.
Okay. All right, and I believe that I saw Mr. Wolf here. Mr. Wolf, you have anything to say here today?
Madam Magistrate, Edward Wolf, representing Starlight Tower. I'm a member of the Board of Directors and the owner of Unit 108. I think we've got everything in line, and we're prepared to take care of the administrative cost.
Okay, perfect. All right, then I am going to find that the property was in compliance as of August 6, 2025. I am not going to assess any fines, but I will assess the $330 in reasonable administrative costs of the city. I have your email address. You will get an order to that effect. And thank you very much for your due diligence on this. It's one of the easiest ones I've had so far, so.
And we don't want to be back. Thank
Yeah,
you.
well, I hope, no offense, I hope I never see you again, at least in this context.
Thank you very much.
All right, moving on to 3E, 20240470, City of St. Pete Beach versus 333 Capital LLC.
Okay. Iaka Ruckshell, City of St. Pete Beach Code Enforcement. This case involved some outdoor storage and a carport that was erected. Your order gave a compliance of a 30-day extension due to unforeseen circumstances with the contractor. They had to comply by 8/15. Took pictures of it yesterday. Overhead, please. So the carport has been erected, the structure has been painted. However, there is still debris inside the carport, kayaks, things like that, outdoor storage, where, and boards, surfboards and stuff, where the car can't even park in there. Building materials and such on the side. This new pile of concrete has seemed to have appeared recently. So, there's there. Yeah. And this vehicle that's parked there, it does have a flat tire, and it was filled with looked like it was being used for storage. So,
That
as
that was
far
not
as-
part of the original
that was
code
not
case.
part of the original thing. However, there is substantial outdoor storage that remains. While the structural issues, the carport, the painting and such were taken care of, the debris remains. I did speak with the renter
The tenant, mhm.
lives in there, and I did remind him that all that stuff needed to be cleaned up, but as of yesterday, the debris was still there. So
Okay.
I would be seeking, let's see. Phillips. $250 in fines from 816 plus $330 in admin costs.
Okay. All right, is anyone here on behalf of 333 Capital LLC? Anyone here on behalf of 333 Capital LLC? Mr. Billups? I don't see him. Okay, so he did go ahead, the carport was done, the fascia board's all done, the paint is done. The only issues is, and we're considering the kayaks underneath the carport to be inappropriate outdoor storage?
Correct.
Okay, but the chairs and things that were there before were not?
There's still chairs underneath that carport. I just couldn't see it because the car is parked there.
Sure.
There's still tables and chairs and stuff out there.
Right, and that was okay to be there. So that's, I'm trying to figure out what the city finds as inappropriate outdoor storage.
Right, so there's building material, looks like sandbags on the side of the house.
Sure, yeah, I agree with the sandbags, and I agree with the cement, just for purposes of my order to give them specific what needs to be cleaned up.
Kayaks.
The kayaks
and
are
like
considered-
surfboards.
So kayaks and surfboards are inappropriate outdoor storage, okay. Okay. All right, I am gonna find that the property is not in compliance with, it's in substantial compliance, but not in complete compliance with my final administrative order. I am going to assess a fine of $50 per day, starting on 8/16, and running until the property comes into compliance, and then I am going to assess the $330 in reasonable administrative fines. The reason for the $50 a day is just because the property is in substantial compliance. The larger issues were the carport and the fascia board, and the testimony from Mr. Billups was that was a result of the hurricanes. So hopefully that will be a little bit of a motivator to get them to come into full compliance, to remove the concrete blocks that are new and out there, as well as some of the other construction material and the kayaks. All right, moving right along. Number 3F, case number 2024-0529, City of St. Pete Beach versus Richard Allen Long Revocable Trust.
Correct, Shell Code Enforcement, City of St. Pete Beach. This case was about the unpermitted work in the rear of grilling and chilling property. As of this morning, they have met compliance and removed all the unpermitted structure, and I do have the building official here to attest to confirm that, because it just happened this morning, and that the plumbing and electrical is secured. So,
Okay, give me a second. I don't know that I have the last order in here.
your last order was they had to remove the bar area by September 2nd. It's a 2-week extension.
Yeah, I don't have that order in here. Okay, so September 2nd was the date that I gave. Mr. Okay, perfect. All right.
Good morning, Luke Curtis, building official for the City of St. Pete Beach. I did visit the site this morning, and the unpermitted work has been removed.
Okay, so the property is in compliance as far as the unpermitted work, and everything is kind of either shut off, sealed up, or
Correct.
removed from the property?
Yep.
Perfect. Okay, all right. Thank you very much, Mr. Curtis. I appreciate it. And have you been, Ms. Rexdale, have you been in contact with the property owner at all to find out when that finally got removed?
The renter,
Right. I'm sorry, not the property, yes, the renter, the tenant.
this morning,
This morning was when he contacted you guys?
we're talking about the grilling and chilling property, right?
Yes, so my orders say that once the properties come into compliance pursuant to the respondent, they're to contact the city to
Right, so there was a
schedule
bit
an
of-
inspection.
Miscommunication there. We only were able to do the inspection this morning. The building official he was a bit busy. So the last remnants of what needed to be done.
Were inspected this morning. My question is, when did the respondent give you guys a call to let you know they came into compliance?
They didn't call us. We had to send Luke out there to go check it out, and he wasn't able to do that until this morning.
Okay, so, okay. That's what I'm just trying to figure out, because it's their responsibility to give you guys a call. So if you wouldn't have gone out there, they technically wouldn't be in compliance. My orders all have that information in there, so, okay.
But we're not seeking any fines, just administrative
The
costs.
$330.
Yes.
Okay, so I will find that the property is in compliance as of today's date. I'm going to not assess any fines. Oh, well, first of all, anyone here on behalf of the property owner? All right. Mr. Long, do you want to say anything at all? Yes, please, yeah, just for purposes of the record.
This concerns grilling and chilling, right?
Yes.
Okay. I spoke to Jason yesterday,
Mm-hmm,
and he said he's through with trying to do anything with it.
yeah.
And I believe he had sent Brandon, some pictures showing that everything had been removed. I don't know exactly what date, but it's been fairly recent because I was on the emails as well.
Okay,
And so as far as I'm concerned, that's a done deal.
right, I understand that.
Okay.
Okay, perfect. Well, thank you so much for being here. I know, you're a busy man. Yeah.
Madam Special Magistrate Pete Dewar, you are correct when you just mentioned about us not being aware. We actually went over there earlier this morning, found out that the property was still not compliant. Luke had to go back a second time to take a look to ensure that the property is compliant, and I'm just clearing it up for everyone in the room.
That all happened this morning?
That just happened, yes, ma'am.
Okay, but regardless, the property is in compliance
Yes,
right
ma'am.
now?
Yes.
Okay.
Thank you.
Okay, yeah, not a problem. Okay, so I'm going to find that the property is in compliance as of today's date. I am not going to issue any fines. However, I am going to assess the $330 in administrative costs of the city. That case went on for quite some time. All right, moving on to 3G, case number 2024-0699, City of St. Pete Beach versus Jennifer Franco.
Yes, Ayaka Ruckdashell, Code Enforcement, City of St. Pete Beach. This case involved to apply for an after-fact permit.
Right.
And the date was given
Got it.
for compliance by September 2nd.
I believe the order's was that July 30th or the new one? I don't have the new orders, I only have the original orders.
Okay. That would have been from the last magistrate, so it would have been July, yes. They have obtained a permit or applied for a permit as of August 22nd. So we would be only seeking administrative costs on that, $330.
Okay, so the compliance day you're saying is as of,
September 2nd, according to your order. And they applied for,
so they were compliant on August 22nd.
correct,
No administrative fines, but you are seeking, or no fines, but is seeking administrative costs.
correct.
Okay. Is anyone here on behalf of Ms. Franco? I know that she is not here. Anyone here on behalf of Ms. Franco? Okay, seeing no one, I will find that the property is in compliance as of August 22nd, 2025. I'm not going to issue any fines, but I am going to assess the $330 in reasonable administrative costs of the city. Moving to 3H, case number 2024-0584, City of St. Pete Beach versus Park Shore Investments.
Okay. Ayaka Ruckdashell, City of St. Pete Beach Code Enforcement. This was an application to apply for a permit. Your last order gave a compliance date of September 2nd, a 2-week extension. They have applied for the permit, however, it was had been denied by the fire department for missing information at that stage. As of this morning, the permit was still in review as they had not supplied the information, or they're still missing information that hasn't been issued yet.
Okay.
So we would be asking for $250 in fines from September 3rd, plus administrative costs until they obtain the permit.
Okay, thank you. Anyone here on behalf of Park Shore Investments? If you could please come up, state your name and affiliation with Park Shore Investments for the record.
Good morning, my name is Emma Gomez, and I'm here to represent Park Shore Investments LLC.
And what is your affiliation with Park Shore Investments?
I'm the registered agent for Park Shore Investments.
Thank you. And you have you have the corporation's authority to speak on their behalf here today?
I do.
All right, go ahead.
We were not aware that the permit, the original permit that we applied for on July 24 was denied. We never received any notification. I found out about that when I was here last Wednesday. And the original contractor that we had submitted the application with was rejected. So on Friday, I was here again, and I've submitted a new application with listing a general contractor for a permit. And we started with that on with the new application on Friday.
Okay. Were you aware that this code case existed?
I received the notification that we had to come in front of Magistrate, but we had already applied for the permit back in July, so I had no idea that it was rejected. Because whenever I went online to check the status of the permit, it was just showing pending, pending, pending. It never showed that it was denied.
Okay, and I believe that the testimony at the last hearing was that, well, there wasn't any testimony from you or anyone on behalf of the corporation because no one bothered to show up.
We didn't know that we had, because originally our meeting was rescheduled, was canceled because there was some sort of construction going on here at the city, and we were not notified of the new date. I just received a new notification for September the 8th.
Okay, all right. Anything else from the city?
And I had the paperwork of what was submitted on last week.
And that's presently either been denied or is in pending review?
This is, I believe, what they have in pending review now.
2505716, yeah.
And keep in mind, this is for an after-the-fact permit, so this means that the work has already been completed.
Correct.
So can you explain to me why? So you're saying you applied for original permit, you didn't know it was denied, you continued on with doing the work, even though you didn't know that the permit was denied, but it also had never been issued?
No, we had to do the permit, like we did the work without the permit because the original contractor that we had, he said that he was applying for the permit, and he disappeared on us.
But you still completed the work without having a permit?
I believe so.
Okay, all right, thank you.
Mm-hmm.
All right, anything else from the city?
Just at the last magistrate, Joanne Bolin, the permit administrator, did confirm that the email was sent to the contractor on file at that time, advising them that there was missing information. So that correspondence was done.
Understood. Okay. And just one more thing from the respondent. The correct address for the property owner is 44349 Low Tree Avenue, Suite 103 in Lancaster, California? Okay. Okay. All right. I am going to find that the property is not in compliance and is not in compliance with my final administrative order. I have confirmed that the notices were all going to the proper address per Chapter 162 that was on the tax collector's website and the property appraiser's website. The work was done without a permit. So I'm going to assess the $250 in reasonable, the $250 a day in fines from 9/2/2025 until the property comes into compliance with my order, which is to secure the after-the-fact permit, plus the $330 in reasonable administrative costs of the city. If you would like a copy of the order, if you could just make sure that I have your email address, otherwise it's just going to be mailed again to the California address, and I don't have any control over the United States mail system, so when it gets there, how it gets there is how snail mail goes. All right, and then moving on, And does the city, and I'm going to include in there the reasonable recording fees of the city if it's necessary to do so?
Correct.
I will also include that in my order. Moving on to 3I, case number 2025-0401, City of St. Pete Beach versus Matthew Getz.
Yes. Iacca Rec Shell, City of St. Pete Beach Code Enforcement. This property had overgrown vegetation, and your last order gave them 2 weeks to comply with as of September 2nd. There's been no contact with the owner, no correspondence, and these are the latest pictures. Overhead, please. Nothing has been done. It's still overgrown. See. So the city will be seeking $250 a day in fines from September 3rd, plus $330 in administrative costs.
Okay, anyone here on behalf of the property owner, Mr. Getz? Is Mr. Getz here? Matthew Getz, or anyone for 429 70th Avenue? Okay, I'm going to find that the property remains to be in violation, is in violation of my final administrative order. I'm going to assess $250 a day from September 3rd, 2025 until the property comes into compliance, as well as $330 in reasonable administrative costs of the city and any reasonable recording fees should that be necessary. All right, moving to 3J, 2025-0388, City of St. Pete Beach versus Gulf West Properties LLC.
Yes. So PowerPoint, please. Yeah. So this case, Iacca Rec Shell, City of St. Pete Beach Code Enforcement. This case was deferred and extended, given continuations, so it hasn't been quite presented yet. And so this is case 2025-0388. Gulf West, respondent is Gulf West Properties, LLC. Violation address 7060 Boca Ciega Drive. Violation description, the property is in violation of section 98-66, residential and commercial property maintenance, A, B, 20, 22B, 1 and 3 of the Code of Ordinances of the City of St. Pete Beach. The case summary was the initial inspection was on June 19th. This is a notice of repeat violation that was occurred and dated June 20th. The notice of hearing is dated and posted on the property as of June 20th as well. This is a true and accurate representation of what I witnessed. This is a picture of the affidavit of posting on June 20th. The property remains overgrown, lots of grass and weeds. More overgrown grass and weeds. This picture shows the height of the overgrowth, greater than 10 inches. Tree obstructing overhanging sidewalk. And these pictures were taken on June 24th. Where they had cut the overgrowth.
So these are demonstrating compliance from the previous code case?
Correct.
Okay.
So as of June 24th, we are saying that the property came into compliance, which made it only 6 days out of compliance from your order. So the corrective action here was the property had to cut and maintain the grass and weeds regularly and continue to ensure that the tree is not obstructing the sidewalk. The property is compliant, and the recommended fine is $500 per day because this is a repeat violation starting on June 19th, 2025 until June 24th, 2025, totaling $3,000 plus $330 for administrative costs and any lien recording fees that may be associated with this case.
Okay, and just for purposes of clarification, the original violation that forms the basis of the repeat violation was from November of 2023, correct?
Correct.
And then there was another repeat violation. This is a multiple repeat violation, correct?
I'm supposed to request an order for fines as from the repeat violation from 6/19.
Right, but that's not my question. My question is, you've asked for $500 for 6 days' worth of clearing vegetation, $500 a day, so $3,000. I'm trying to find justification for assessing a $3,000 fine for 6 days of overgrown vegetation. I see that there's an original violation that was from 2023, which is the original violation, and there is a repeat violation, it looks like it was July of 2024, which was for about 3 days. That was also a repeat violation, but I assessed $250 a day. And here we are again a year later with the same violation for a repeat violation again for 6 days. But it does look like we've continued this one a couple of different times. But the property owner was in compliance as of June 24th.
Correct, you are correct.
So is there a reason, if they were in compliance on June 24th, why on July 14th, we continued it to the August?
I believe the owners were sick at the time, and then just, or the date in July wasn't convenient because of the roof repairs, and they weren't able to make it, so we continued it on to here, this date.
Okay. Okay, all right, thank you. Anyone here on behalf of Gulf West Properties LLC? If you could please come up, state your name and affiliation with the property, or with the LLC for the record.
Vicki Dykens, just kind of help the lady out because I'm kind of local to the area. So I frequently drive by and tell her when the property looks like it needs to be attended to, you know, after the storm. And
Do you have the authority on behalf of Gulf West
she gave
Properties?
it to me on this case maybe, or the one in 2023.
The one in 2023, but I need to make sure that I still, because I have that the registered agent is CT Corporation Systems, so I've got
So I
two
really don't-
LLCs.
I don't have any authority for this particular case, just the one in 2023. She just thought I could come down here and speak on her behalf.
But so she gave you authority to come today?
Yes, but not, last time I think she sent a notarized statement in, but I don't have that with me this time, no.
Okay, but today you have her authority. And what is her name?
Sheila Hutman.
Okay. And do you happen to know her affiliation with the LLC?
She's the owner.
Okay. Okay. All right, I'm sorry, Ms. Dykens, for all that interruption. And
That's okay.
go ahead with the...
So I'm just here to kind of defend her case, just with the storm, and she's had the property up for sale during this June time, I believe. You know, I just here to kind of plead a case that she's innocent and is trying to make it. Mr. Cruz, I think, was throwing a lot of things on her as far as making the property correct. I think she was confused on what she needed to get done, but she just had a lot of trees trimmed, and, you know, and I've told her to hire a monthly landscaper to keep the lawn maintained, so it doesn't have that overgrowth. So hopefully, you know, she said on Friday that she did do that. So going forward, we should not have a problem, but I think just during that June 19th, June 24th, the property was up for sale, and it just got away from her.
Okay, do you happen to know if the property's still up for sale?
No, she pulled it off the market. She's looking into demo it. Now she's been getting permits to just level the property because it's just in total disrepair at this point after the storm.
Okay. All right, thank you, Ms. Dykens,
All right,
I appreciate it. Anything else from the city?
No, ma'am.
Okay, I am going to go ahead and find that the property is in violation of the stated code sections. It is very clear that this is a repeat violation. I am not going to assess the $500. I am going to assess $250 a day from 6/19 to 6/24, plus the $330 in reasonable administrative costs of the city, and any necessary costs for recording if it needs to consummate a lien. I will say, Ms. Dykens, if you could go back to her, if I see this property again, I'm not going to reduce it to $250. I don't care if it's for 3 days, 2 days, 2 weeks. It's a repeat violation. This is the third time I'm hearing this in 3 years. So just so that she understands the next time it's a repeat violation, unless there's some extenuating circumstances, I'm inclined to do $500 a day. All right, moving on to 3K 2025-0339, City of St. Pete versus Rhonda Schroeder.
Schroeder.
Request for dismissal.
Okay, we believe in the last magistrate we had requested for a dismissal for that case versus Schroeder.
Yeah.
Unopposed motion for the sales.
Yep.
Okay. All right. All right, I guess I will take it on the city's. Is there anyone here on behalf of Ms. Schroeder? I don't know why she would oppose dismissal, considering she probably doesn't want a code case. Yeah, and I understand that. I just don't have anything from Ms. Schroeder saying that it's unopposed.
We received an email from her counsel, I believe.
Okay. Do you know who her attorney was?
I can look it up. We come back to this.
Not a problem. If you could just get me their email address so that I can send the appropriate order of dismissal, but I will consider this dismissed. And we'll get an order of dismissal to that effect. Okay. No repeat violations that were not otherwise continued. Moving on to new cases. Case number 2025-0394, City of St. Pete Beach versus Mara Martin.
Okay, Ayaka Rectichow, City of St. Pete Beach Code Enforcement. This case is 20250-394. The respondent is Martin Mara. Violation address 6802 Gulf Winds Drive. Violation description, the property is in violation of section 46-33, 1A, 2, and 3, enumeration. 98-65, item 4, unsightly conditions, and 98-66A, B, 20, C-2 and 3, residential and commercial property maintenance of the Code of Ordinances of the City of St. Pete Beach. The case summary, initial inspection was on June 20th, 2025. The notice of violation was sent dated June 23rd, 2025. Notice of violation compliance date was July 7th, 2025. And the notice of hearing dated and posted on the property as of August 25th, 2025. This is a true and accurate representation of what I witnessed. This is the affidavit of posting, August 29th at the property. This is vegetation and the debris that was on site June 20th. Overgrown grass and weeds. And you can see the debris in the back. More overgrown grass and weeds. July 21st. The property looked like it had been trimmed. However, there is still debris visible in the back, sandbags along the back fence there. And sticks and stuff. So there's a close-up of the debris as of August 1st. The picture was taken, sandbags in the rear, building material in the back left-hand corner. August 19th, that was the property. Cleaned up, however, the debris still remains in the back. So the corrective action, the property must remove debris, sandbags, and other building materials. The property is not compliant. Recommended fine is $250 per day, beginning 3 days after your order today, let's say September 10th, plus $330 in administrative costs and any recording fees that may be associated with this case.
Okay, and have you had any contact with the property owner?
No, ma'am.
Okay.
Nothing.
All right, anyone here on behalf of Martin Mara? Anyone here on behalf of Martin Mara? 6802 Gulf Winds Drive. Okay. I am going to find that the property is in violation of the stated code sections. I am going to allow for 14 days from the date of my order for the property owner to come into compliance by removal of the sandbags and other building materials that are visible from the street in the back of the property. And then we will reconvene. What's the next date? October
6th.
6th. We'll come back on October 6th for a status conference and figure out if the property is in compliance or if we need to assess any fines.
Okay. Thank you.
Okay. Moving to 5B, case number 20250471.
Okay.
Did everyone just go on vacation and leave you here by your lonesome for all the code
Good.
cases?
Good. Okay, case 2025, Iacca Rock Shell City Sandy Beach Code Enforcement. Case 20250471, the respondents, excuse my mispronunciation, Vidula Krishnamurthy and Srivastana Anindita. The violation address is 411 55th Avenue. Violation description, the property is in violation of section 46-33, items 1 and 3 enumeration, 98-66A, B 20 of the Residential Commercial Property Maintenance of the Code of Ordinance of the City of St. Pete Beach. The case summary, initial inspection was July 15th, 2025. Notice of violation dated 7/15/2025. The compliance date given was July 30th, 2025. Notice of hearing dated and posted on the property August 25th, 2025. This is a true and accurate description of what I've witnessed. The affidavit of posting on August 28th on the property. These are some of the pictures of the overgrowth overtaking the driveway. Heavily overgrown. August 1st, still overgrown. The corrective action is the property must maintain the landscape and remove dead vegetation. The property is actually now compliant as of the PowerPoint date. They sent me pictures on September 3rd. So we will not be seeking any fines, but however, just administrative costs.
Okay. Anyone here on behalf of the property owners? Krishnamurthy Vidula or Anandita Srivastava? Okay. I will find that the property was in violation of the stated code sections and now is in compliance as of September 3rd. I am not going to assess any fines on the property, but will assess the $330 in reasonable and administrative fees of the city.
Yes.
All right, and moving on to the last case, the lien reduction case. Case number 20240281, City of St. Pete Beach versus Richard Allen Long Revocable Trust with Mr. Allen as trustee.
Correct. Good morning, Madam Special Magistrate Pete Doerr, Code Enforcement Manager for the City of St. Pete Beach. I'd like to present to you the lien reduction request application.
I'm going to keep this copy. Yes, ma'am. Thank you.
Please go to the overhead. Thank you. As you see on the overhead, this application was made by Mr. Long through his attorney, Mr. Melendi. and you can see their very detailed description of why the lien should be reduced to $10. The city is requesting a full imposition of lien, $49,500, plus administrative costs of $325.
Okay, I do have the application. Anyone here on behalf of the property owner? His attorney, would you like to argue the position that is set forth in the application here today?
May I approach you?
You certainly might. Thank you.
Thank you. Thank you, sir.
And I will warn you, too, that this is not the time to relitigate the matter that was the underlying violation. I understand the purpose of the application is, it looks like the argument is that the inappropriate violator was addressed here. But if you're trying to set forth why the owner of the property should not be held in violation, that's one thing.
I'm not.
Okay. There's a lot of case law in here and a lot of pictures of the signs, and I'm not here to determine whether the violation existed or not again.
I understand. May I?
You may.
Good morning, Madam Magistrate, Mr. Brooks, Mr. Dwyer. My name is Joe Melendi. I'm 87 years of age. I've been a member of the Florida Bar since 1962, some 63 years. For the most part, I'm retired, and it's only by accident I'm here today. Despite the fact that I've been a lawyer for a long time and become fairly competent in various areas, in fact, I've been a judge of industrial claims. I've been the president of my Hillsborough County Bar Association. I've done probate, real estate, personal injury, no criminal. But I've never had the opportunity of representing a client dealing with Florida Statute 162 or Article 9 of the city's Code of Ordinances. Notwithstanding, I've made a sincere effort to become familiar with both these bodies of law. I appreciate the opportunity to appear before you on behalf of Mr. Richard Long, trustee of Richard Allen Long Revocable Trust, the owner of 6800 Gulf Boulevard, in the matter of his application for reduction of the fine imposed by you in your order of September 11, 2024, as allowed by Section 23-283 of Article 9 of the City's Code of Ordinances. According to my calculations, the fine now totals some $49,825 imposed by you because of the owner of a restaurant known as Branzini installed all without his knowledge and consent, Mr. Long's knowledge and consent, sometime in April of 2024, without the requisite permit. It was an innocuous and harmless, perhaps oversized sign reading breakfast, lunch, dinner, full bar, above a restaurant. As stated in the application, there are 9 good and substantive reasons why the resultant fine imposed by this tribunal in September of 2024 should not only be reduced, but, in my view, eliminated in its entirety. I'm sure this case, every case that comes before you is rather unique, each with its own set of circumstances. But I suggest today that you will find this case most unique, and I doubt that you will ever experience anything like it again. Bear with me. While Mr. Long was not factually and literally in a coma during the year 2024, for all practical purposes, he was. He was residing in the remote jungles of Panama, had absolutely no clue what was going on here in St. Pete Beach, just as if he were in a coma living here on St. Pete Beach. He had no idea about the events swirling around his property at 6800 Gulf Boulevard, and he was totally unaware of his environment, in this environment. Had Mr. Long been in fact in a coma during the year 2024, would this tribunal not feel compelled today to eliminate the fine in its entirety? After returning from the jungles of Panama, where he was residing with his wife and young son, Arlo, to his home in Mayaca, his domiciliary, his legal residence, to meet with his accountant in preparation of his 2023 tax return, analogous to coming out of his coma. He was greeted on March, greeted sometime in March, with a lien payment reminder from Mr. Pate Dewar, St. Pete Beach Code Enforcement Manager, claiming that he owed $46,575 and that the city intended in substance to collect it. He had absolutely no clue what that could possibly be all about. He had no clue what was going on. He was a little bit confused. That was on a Friday, a late Friday. The reminder did not offer any explanation why he owed $47,000 worth. The only thing he knew was that some years ago he had leased that property to a Mr. Rick Meyer, a long-time and well-known businessman here on St. Pete Beach. So he called Mr. Meyer that next Monday morning, who was then living in North Carolina, and relayed having received the payment reminder and wanted to know what the hell was going on. Mr. Meyer told Mr. Long on that Monday that he had no idea either, but that he would try to find out and get back in touch with him. Perhaps I should stop there. But there are more nuanced reasons, in my view, that I think deserve being presented. As I understand it, the state adopted a mechanism for cities and counties to use to enforce their codes without having to go to the courts. A system that would be more expensive, more efficient, more effective, less expensive, and equitable. It passed Chapter 169, and that piece of legislation authorized cities and counties to create either a code enforcement board composed of 5 to 7 folks, or appoint a special master like you to act somewhat as an impartial tribunal with many of the same powers possessed by a civil court judge. It hoped that this would result in a more efficient, effective, inexpensive, and equitable system of enforcing its codes. Well, it would be, if implemented properly and rationally. I am not here naive enough to think that it will not be uncomfortable for you to base your decision in any way on the inefficiency and ineffectiveness of colleagues. But the facts are the facts. I fully expected today that I would have the opportunity to examine Mr. Luis Cruz, the code enforcement officer assigned to the case, and show how ineffective, inefficient, and irrational were the methods he employed. They were the root causes, the proximate causes, if you will, that permitted a non-compliant sign at 6800 Gulf Boulevard to remain in place for another 339 days after discovery by the department. They were the root causes that allowed any fine whatsoever to have been imposed against the owner, much less one that was allowed to fester and accrue at the rate of $250 a day for another 198 days. In this regard, after seeking to be assured that Mr. Cruz's attendance at today's hearing would be made available to me for examination, the city attorney, Mr. Brooks, advised me, quote, Luis Cruz is no longer employed by the city of St. Pete Beach in any capacity and will not be attending the lien reduction hearing. I then sought to have Mr. Cruz subpoenaed to testify today, and was advised, I think, by Mr. Brooks, or perhaps by Mr. DeVore, that the city had no power to subpoena Mr. Cruz's attendance here today, despite wording to the contrary, perhaps, in both the ordinance and in the statute, granting the special magistrate the power to subpoena witnesses, compel appearances. I then reached out to the city attorney and asked if he would stipulate to a listing of what I considered unquestioned facts I fully expected would be shown by my examination of Mr. Cruz. And that listing appears in binder number 17, item number 17 of your binder. Mr. Brooks advised me that he would not be able to stipulate to such, but indicated I would be able to make a presentation of anything I thought was relevant at a lien reduction hearing. Item number 17, in my view, is very relevant. And if you find yourself unable to consider item number 17, I would like the opportunity to call another witness employed by the city staff, Mr. DeVore. The city, Mr. Brooks advised me that he would not stipulate, but that I could present what everything I thought was relevant, and I have, and it's contained in that binder. Because I have such firm convictions that the city can do better, I am bold enough to hope that today's proceedings might have some constructive value to whomever might be listening and willing to listen. And just maybe today's hearing will lead to some policy changes in the manner in which enforcement of its code is implemented in instances in which we have commercial property, a tenant, and an absentee owner. The two barrier signs referred to in the notice of violation were removed even before the notice of violation was issued on May 7, 2024. There was a gap there. They were removed on May 5. Photographs of the banners and signs were made on April 29. By the time the department got around to issuing the notice of violation on May 7, the banner signs had already been removed. And we'll explain why and how.
I think I only assessed the fine for the large sign that was affixed to the front of the building.
There were two banner signs. One fastened on the north wall of the restaurant and one fastened on the south wall of the restaurant, but under the over the overhang they have there. Presently exists no non-compliant conditions on the subject property, and all ad valorem taxes have been paid. To Mr. Long's knowledge, neither he nor the trust is presently indebted to the city. I've prepared a binder. I hope that the special magistrate will entertain reviewing before making its judgment and consider all of the circumstances surrounding this matter. In order to save a great deal of time, perhaps counsel for the city might agree that you may consider the entirety of the binder in making your decision what should be reduced and to what extent. And I don't know whether Mr. Brooks will entertain agreeing that she may consider everything in the binder that's contained.
No objection.
In connection. No objection? Beautiful. Thank you, sir, very, very much. All right. You want me to call my witnesses now?
I'll be honest, we've never had witnesses. I've never taken testimony. It's merely an application for a lien reduction request. If you would like to call witnesses unless there's an objection by the city. I don't see that there's anywhere in here where I have criteria to look at. It's just whether or not you meet the requirements.
We have no objection to any witnesses.
Okay, I need to make sure that your witnesses are going to, I guess my concern is that the basis of your argument for the lien reduction is that Mr. Long shouldn't be responsible for the lien because he was not, quote, the violator. Or should not have been made the violator. Is that correct?
Well, that's one thing. Yes, it was irrational to name him the violator when the sign was above a restaurant, advertising what kind of restaurant, what kind of food was being served in that restaurant. The code enforcement officer could have known and should have known that the owner and the person occupying the premises were two different people. They could have simply looked at the records who was occupying the premises. They could have looked at the what they call the business stamp, or what is it?
Business tax receipt. Right. I think I saw the argument.
And he would have known that there were two different people. If you will.
So I'm willing to entertain your witnesses. I just want to make sure I'm not here to rehear whether or not there should be a violation against Mr. Long, or whether or not notice was proper, or any of those things, because those arguments have been waived, and so under the law, I can't entertain them. So you may present your witnesses. I just need to make sure that they are in support of why the lien reduction request should be granted and not relitigating the underlying matter.
Because you're imposing a fine on someone that had no idea what was going on. That alone, to me, suggests that there are some equitable reasons why you should reduce this fine. And there were legitimate reasons why he was totally unaware. He was in the jungles of Panama, had no idea. Nobody was able to reach him.
Okay. You may produce your witnesses for that. What I'm going to say to you, or I'm going to ask, and I will likely inquire of your witnesses, was the address on the property appraiser's website and the tax collector's website for the name of the trust, Was that the correct address that was on file?
Correct.
And it was sent. So notice under Chapter 162 was legally proper.
Correct.
And so regardless if Mr. Long was in Panama or if he was in a coma, which I will tell you, I do not like that argument. A medical condition is not going to live in the jungles. Excuse me. A medical condition is not akin to living in the jungles voluntarily in Panama. Those are two different things. And if you own property, this is not, we're not talking about his primary residence either. This is a commercial property where there are multiple tenants. So I'm just letting you know, be careful where you're going with this, because if it is, he shouldn't be held accountable because notice wasn't proper, fine. But if it was, gosh, he was in Panama, he had multiple, he didn't change his address because of some reason, I don't know that I'm going to find that convincing.
I understand that.
But go, please, it's,
I understand that. But the notice that was sent to him, the notice of violation that was sent to him, was returned to the city
sure.
by the post office and undelivered, so that it's clear that Mr. Long had not received a copy of that notice of violation. And instead of then the code enforcement officer of then simply delivering a copy of the notice to the restaurant. Why didn't they do that? That seems so rational to do. Look, we know that Mr. Long, the owner, didn't get notice. We want to give you an opportunity to correct this thing. And here's the notice of violation. There's nothing in the statute that prevents that officer from having done that very simple, rational thing. They didn't do that. They basically kept secret the notice of violation from the tenant who was responsible for the violation.
You're arguing that notice was not legally effective? Or are you arguing that equitably, even though the city followed the letter of the law in Chapter 162, they should have done more?
Correct.
Okay, I'm not going to entertain the argument of should have done more.
Because the point is, the very point is that had that restaurant owner been given a copy, even a courtesy copy of that notice, that sign would have come down in 2 seconds. And the evidence today would be able to show that.
Okay, and again, I don't have testimony. We typically don't take this kind of testimony because, again, this is relitigating the notice issue. But I'm going to ask a question of the city. Every case that I've had since I've been magistrate here, not only have you all given me confirmation of certified mailing to the property owner, who is usually the violator almost exclusively underneath your code, but you have also provided me with an affidavit of posting that notice to the property.
There was a notice that was posted for the hearing. It was posted on the property where the restaurant is. Where the restaurateur would have seen it on July 1st. Yet the violation for the breakfast, lunch, dinner, full bar sign remained until March 25th, 2025, nearly a year later, I guess 10 months later.
And at no point do you know that the property owner or the tenant contacted the city? And clearly, the information here is that the tenant did not contact the property owner.
Typically, in leases, commercial leases, there's a compliance with all laws provision that says the tenant must comply with all laws.
Right, which, again, the city's not privy of contract between the property owner and the tenant, and that's probably a wise provision to have. But from my perspective, I'm just trying to figure out, the city almost exclusively posts the property as well. So
Yes.
just making sure, to the respondent's point, legally, I'm not trying to frustrate you, I understand, but I'm also trying to be judicial economy here, or pseudo-judicial economy, as it were. I don't want to re-argue notice. Those arguments have been waived. I am cautioning you that what should have been done, unless it was illegal, I can consider for equitable reasons, but notice was made.
Correct.
And it was posted to the property, because I specifically recall that, which means the tenant also knew.
My argument is that the notice of violation was required on both the statute and the ordinance to be posted at the restaurant.
It is not required to be posted legally by the statute.
I would beg to differ.
Okay, please cite me to that, because that I can consider.
But whether it was requested or not, it would have been rational for them to have done so.
And I'm not here to argue what's rational, what's practical. Often, as you know, you've practiced for a long time, the law is not rational or practical.
Right.
But if you can point me to a legal basis as to how the city's required to post as well, I will consider that.
That was in reference to a hearing that was being scheduled before you, but long after the notice of violation had been returned and as has not having been delivered.
And under Chapter 162 or the city's code, is there a timeline on that?
Pardon me?
Under Chapter 162 or the city's code, does it not give the city discretion to call the property owner or the violator to a hearing, not a requirement to do so? And the only thing under Chapter 162 is that hearing notice shall be reasonable.
Right,
And I made those determinations at the hearing.
right.
So we're here as to why I should consider the lien to be reduced. When a hearing notice was posted on the building in 2024, is that correct? You said July 2024?
On the booklet that was handed out on
Right.
tab 17 and paragraph 17, they say, and we agree, that additionally on July 1st, 2024, Mr. Cruz posted a notice on the glass entrance door of the restaurant wherein Richard Allen Revocable Trust is identified as the owner, and indicating that the reader might want to contact the owner and tell them about the hearing.
And then a year later, the sign was still there.
Yes, and
So
if you look at the
your argument with regarding it should have been done, it was, sign still remained, the tenant didn't contact the property owner.
If you look at binder number 10, which is the copy of the notice that was purportedly posted, nowhere in that notice does it describe what the violation was. So that had it been seen by the tenant, the occupant, and had a reference to some large sign reading breakfast, lunch, dinner, and full bar, that would have been a serious and significant piece of information received by that owner of the restaurant, and action would have been taken immediately to find out what needed to be done, and if it was not permissible, take it down, so that there would be no accrual of any fine had the description of the penalty, description of the violation been included in the notice. It
Your
was
Honor,
not.
Yes.
in the notice, it says, "The hearing is in reference to your violations of the City of St. Beach Code of Ordinance as further described in the attached affidavit of violation and request for hearing." And that's not included in the binder, but typically those notice of violations are attached to the notice of hearing.
I understand that.
We can enter some testimony about that.
All right. All right, go ahead, Mr. Melendi.
Then, when the notice of hearing before you on August the 12th, it was sent by certified mail to Mr. Long. Again, it was returned to the city as not having been delivered,
Sure.
right? And at that point in time, everybody ought to appreciate the fact that Mr. Long didn't know what was going on. And if you read the case that I've cited by the United States Supreme Court, there's some serious issues to whether or not Mr. Long had been afforded the due process required by the 14th Amendment. And in my view, due process is always relevant and is always something to be considered in a relief or equitable relief. It should never be denied, should never be dismissed. No one in the city attempted to find out was there anything about Mr. Long that was unique that required them to possibly do something more to get notice to him.
And can you explain to me what Mr. Long's responsibility is with regard to making sure that his proper address that he has access to for tax notices and other legally required documents is?
His address was the same.
And
My
the
address.
city sent sent notice to the proper address.
Yeah. Yeah, I don't know that he has any legal obligation to change his address to Panama. Even if he had, it wouldn't have gotten there.
Sure. And I don't
Your
disagree
jungles.
with you, but you're now expanding the scope of the government's legal responsibility and due notice requirements
And exactly what
under the 14th Amendment.
The Supreme Court did just that in that case. When you read
Your
it,
Honor, that case, Jones versus Flowers is a notice of tax sale, and
Agreed.
the case was saying that the government took his property and sold it, which is different. It's a takings. This is a code enforcement penalty that results in a lien, but we're not seeking to foreclose on this property.
I agree with Mr. Brooks. I've read the case. I'm familiar with the case. I don't find it relevant in this context. That's the point I was trying to make to you, is due process was afforded.
the binder's all we have to offer you.
I understand.
In my view, it prays rather compelling to me that Mr. Long is entitled to significant equitable relief because of the circumstances, because of the irrational way of enforcing this code. You know, is it the purpose of the methods adopted by the department in charge of enforcement, is the purpose to secure compliance with the code, or is it to generate revenue?
Well, I don't have to answer any questions.
you don't have to
because
ask.
I'm not under oath.
I understand that. I understand that. But in my view, I would have had some serious question. Why didn't they just act rationally? And had they done so, there would be no fines imposed.
Well, and also you can't say that, right? Because the property owner or the tenant was notified of a hearing and still did nothing.
Because the sign would have been taken down timely within the period provided in the notice of violation.
So then my question is, did your client know about 1 year before, in July 2024, when the notice of hearing was posted on the property, as you're suggesting the notice of violation should, did that correspondence make it to your client?
No. No. The first time
So your argument is invalid, because it wouldn't have mattered, because he's still the tenant, who you're saying should have been held responsible, still did not do the acts that you're saying would have been done. And I can't be here to argue a
The sign would have come down
hypothetical.
is what I'm trying to show you, demonstrate to you. The sign would have come down timely.
Okay, but it did not. And so what is the basis for the application being reduced, the fine amount? Again, I'm trying to get it to the point is, you're saying because Mr. Long isn't technically the violator, even though he's the owner of property, if the city had just gone inside and gone to the tenant and said, hey, you guys can't have that sign up, your testimony, which you're not under oath, but your argument here today is that the sign would have been removed regardless, even though Mr. Long was not available for a period of a few years.
Correct.
But you have no evidence to support that. That even would have been the case.
I can prevent you with evidence to that. Had the owner of the restaurant, I can present testimony today, had he received even a courtesy copy of the notice, he would immediately taken the sign down.
And I am very worried that we are getting into the notice argument, which was already adjudicated at the hearing. But I'm going to allow the city, if you're okay with this, we can certainly move forward. I'm starting to hear some redundant evidence. I'm not hearing anything compelling other than what I've already heard. It seems to be just... So, Mr. Brooks, do you have any response?
Is his question, does he want to call as a witness the owner of the restaurant? Is that what's happening?
I'm sorry, may I?
Your question was, can you, you would like to call the owner of the restaurant to examine? No objection.
And I'm going to ask, to what purpose, and I'm not going to entertain hypotheticals, that he would have taken down the sign, that he would have done something?
That's the testimony he will offer.
Okay.
Mr. Melendi, may I speak for a moment?
Pardon me?
Is it okay if I speak for a moment?
Yeah. Mr.
We have no objection, and we don't have to have cross-examine. He could just speak. It's
This
a
is Mr. Rick
lien
Meyer.
reduction request, not a trial.
Hello, my name's Mr. Richard Myers. I have 3 restaurants there that I sublease from Mr. Richard Allen Long, have been for a number of years. Anytime there has been a violation, I understood it, took care of it. We've met several times in the past, took care of it. I was totally unaware of it. Mr. Long was totally unaware of it. As soon as I found out, Mr. Long had called me and said, hey, what is this $47,000? I don't have a clue. I actually immediately called Stephen. Stephen didn't have any idea. Then I called a lady here at the city, and I'd asked her. She actually thought I was Mr. Long, Richard L. Long, Richard Myers. But anyway, she gave me some information. It's a sign. I immediately called Stephen and said, get those signs off that building. Do it now. Within 48 hours, the signs were removed. That's when we started figuring out, well, hell, this went back for a year. It's like I had no idea. Mr. Long had no idea. But as soon as we knew, action was taken. That's basically, I apologize for not knowing. I was unaware that anything was stuck on the door, and Stephen was unaware that anything had been stuck on the door. Who took it off, nobody's saying. But if we'd have known, immediate action would have been taken. But we had no idea, and I apologize for that. Thank you.
But you were made aware of the notice of hearing that was on the door?
No, ma'am, I was not.
Okay, so the first that you understood anything about
The
this
first time I'd ever heard of it
was when you heard from Mr.
Somebody sent a picture on email. Somebody showed me a picture. I was like, what is that? I had no idea. As soon as we were made aware, less than a week, I think it was less than 48 hours, everything that was tagged. When I spoke to the lady up here, she told me what it was. I told, not trying to be rude, I told Stephen get his ass up on that building and get those signs down, which he did. That is my contention. If we had known, they would have been down a year ago, 6 months ago, whatever. As soon as we were made aware, or I was made aware, and Mr. Long was made aware, and he caught it by, hey, you're late on your $47,000 payment. He calls me. None of us were aware of what was going on. I mean, absolutely, totally unaware. Floored me. I've never had anything. I mean, this carrying on as long as it has is driving me and Mr. Long insane, because this got delayed because of the barbecue. You know what I'm saying.
Yeah.
Our contention is we were totally unaware, and once we were brought aware of what was going on, immediate action was taken.
Okay, thank you. I appreciate that.
Thank you.
I call the restaurant owner.
Yep.
Stephen, he has a Serbian name that I can't pronounce, so I like to refer to him as Stephen.
Two-door Honda Civic. I had to live with that for a long time.
That's okay. I tell people my last name is all Jello because it's the easiest way to pronounce it phonetically. I can understand that.
This is a little awkward for me, but
That's all right.
Stephen,
Oh, okay.
would you state your full name and address?
Stephen Todorcevic and 120 Coquina Bay Drive in St. Petersburg, Florida.
For the sake of time, correct me if I'm wrong. Let Us Entertain You, LLC, was formerly known as Branzini, LLC, a Florida Limited Partnership, it's formed by Natasha Pavlovic on May 8, 2022. Ms. Pavlovic became its sole authorized member. On September 23, 2023, you became a minority member of the company and the company's registered agent.
Yes, correct.
And you became active in the operation of the restaurant along with Natasha.
That was in 2024, but
Okay. And then on December 16, 2023, after completing the conversion of the $6,800 Gulf Boulevard from offices to a restaurant, the company opened its doors and began doing business as a restaurant at that location.
correct, as Branzini.
Okay. And did you ultimately become the sole member and sole owner of the restaurant?
Yeah, correct. After the hurricanes, they had problems, financial problems of their own, and I had an investment. I was a minority stakeholder in that, so I asked to take over the restaurant.
So you are now the only person in charge of the restaurant?
Correct.
Let me refer you to binder number, excuse me. May I put my glasses on?
You don't have to ask me if you can put your glasses on. And there's no, there's no objection. Yeah, we'll allow you to see.
As you can see, I'm somewhat obsessed with this subject matter. Let me refer you to item number 3 in your binder. Is that the lease between Mr. Meyer and your group that, by virtue of which
It is. It is.
Business at 6800 Gulf Boulevard?
It's the original lease, and then I think I'm at the end of the lease, I've been put in as another responsible party.
What he's trying to say is there was an addendum to this lease. I don't have the addendum, in which he's named an additional lessee so that he protects his interest in the lease by having Mr. Meyer agree that he would be a part of the tenants.
And I appreciate this. How would the city have known this? How would the city have known about this? How would the city have known about this?
They could have looked. Who was occupying the premises? They could have looked.
We knew the LLC was occupying the premises,
They could have-
right? The city did.
But how could the city known who was occupying the premises?
No, that wasn't my question. My question is, what's the relevancy of the lease? How would the city have known this? The city's not privy, they're not a party to the lease, and they would have had no idea that this existed.
No, okay, that's all right. They would
Okay.
know that he was a tenant.
That the LLC was a tenant.
Yes, right, by virtue of the occupational licenses.
Okay.
That's all I had to do is look at, and that's one of my recommendations is that when we have a piece of commercial property, that there ought to be a policy of the department to check to see whether or not the owner and the occupant are one and the same.
Sure.
That's a rational thing to do.
And again, I can't consider what might be practical or rational. I can only consider what's legal, and you can make those bids to the Board of Commissioners.
More reasons in my view
Okay.
for the basis of the relief. And that's exactly what I'm hoping to do. Did you even know of who Richard Allen Long was at that time?
No, we only knew about Mr. Myers, who was our leasee, or leaseor, excuse me.
Because you sublease from the tenant that
Correct.
occupied the premises.
Correct, correct.
What he's trying to say is he thought Mr. Meyer owned the property and didn't know anything about Mr. Long's interest in the property at the time.
I had no idea until 2025, after I was called from Mr. Myers, that this was happening.
So then if you saw a notice on the door,
No, I found out
hypothetically,
about
I know
that
I said it
notice.
wasn't going to work in hypotheticals, but if you saw a notice on the door, you would have given it to Mr. Myers, you wouldn't have known about Mr.
If I knew that if I knew that Mr. Long was somehow involved in the property, definitely, or Mr. Myers, whoever. But I just learned about this notice. In fact, I just have 4, I apologize, but I'm being delivered lots of stuff. I was just delivered 4 printer modules for a company that's some kind of a, I don't know, company around St. Pete Beach that had 6800 Gulf Boulevard on it. And this is not just the first time. I've been delivered checks from different people that had 6800 Gulf Boulevard. But regardless of that, we've never seen the notice. And once we learned of this, that this was happening, we came to City Hall immediately.
And you were in attendance at the hearing? Have you been in attendance at any of the hearings on this matter?
I'm not sure. I was here since, well, I've learned about this in March of 2025. But when I learned about it, I sat down with, I think, Jennifer and was the other gentleman, Lewis? We sat down with them, and they told us about some kind of a sign. So after our discussion, I went into the building department to find out, because back of my mind, I remember a sign that was posted on the north wall, which we took off because Mr. Berry, who was one of the people from the city hall, called and told us that, hey, that it had Branzini on it. It was like 3 foot by 5 foot, tacked onto the back wall. That wasn't something that we can do, so we took it off. And I think there's a picture of it, but regardless, we took it off immediately on a call. So we would have gotten.
Stop in there. There, in the binder, there's a picture of the banner attached to the north wall, and that's, I forget what number it is, but there's also a picture of the same wall, evidencing that the banner had been removed on May 5, which was 2 days before the notice of violation went out. That's understandable, because the city discovered the banner existing on April 29,
Right.
and it was removed on May 5, and the notice of violation came in on May 7. But there was a reason why he took it down, was because of the comments made to him by Mr. Barrett. And within a day or so, the banner signs were removed, all just by casual, no formal notice of violation, just a very comfortable, casual, say, look, Stephen, those signs just don't work. We can't allow them. They take them down right away. That's, in my view, that's what this department policy should be. First thing they should do is just reach out to the property owner or to the occupant. We don't know what rules and regulations are that regulate so much of our lives. I know we're charged with knowing it.
That's not a good argument in front of me. We've been here before.
Now, had you received a copy of the notice of violation of May 5, May 7, I forget it was, May 7, 2024, had you received at least a courtesy copy of that notice, what would you have done?
We would have at least we would have went to the city hall first. I mean, I don't want to bother my leaseor with something that I can satisfy.
Right.
But we would have definitely let someone know if we can't do something. It was just a matter, after we met with Jennifer, we went into the desk here and we were given a picture of a sign that was in question. That sign was not the picture of the sign that we're here for right now.
Right.
So anyway, a lot of these things have, happened by happenstance, by people not following up or whatever. But we would have come to the city hall. You guys are only 2 blocks away. Miss Robinson, Lisa Robinson wanted to have a, thing at our restaurant. Why would we not? It's just a sign, and the sign costs like $100.
So then here's my question. You were notified by the city that those signs had to come down. You came to City Hall, you spoke with Jennifer and some other people about the sign. Right, understood. Did you have any conversations with them at that time that signs obviously there's sign regulations. Did you alleviate yourself of what the sign regulations were at that time?
At that time, they were telling me about a sign. In back of my mind, I remembered the sign that we took off. Mm-hmm. So I just wanted to make sure what they were talking about, because we didn't know about this sign, this particular sign on the south side. Even then, when we met with Jennifer, all I knew was a sign, and that's the reason that I went into the desk of the building department and requested a picture of the sign so that I know what it is. the reason for that is that we have a sign, Branzini, right in front, and if we lose that sign, they would think we're a 7-Eleven or something. I mean,
Right, and I understand that. I'm
So
trying
I
to get
wanted to make sure.
clarification that, Mr. Melendi made the point that, we don't always know what the regulations are in the places that we do business. I don't find that to be a very persuasive argument. I think when you operate a business in a jurisdiction, you're required to know what the laws are. You've already been into City Hall. They said, don't go ahead and remove those signs. My question was, did you guys discuss sign regulations? Did you even know there were sign regulations? Sounds like you did. So at some point, did you alleviate yourself of what those, right? The reason I'm asking is I'm seeing a lot of blame shifting here. Is it your fault? Is it your fault? Is it your fault? Is it the city's fault? Whose fault it is? I've already made that determination. So I'm trying to make an equitable determination as to how much should I apportion fault to the property owner who is the violator named in this. That's literally my only job here today, and I am getting very concerned we are relitigating the underlying issues.
On that specific issue?
Absolutely.
Who put the sign up?
Mr. Muntaz, who was one of the people in the restaurant, I don't think, he's an investor, he's just connected to Natasha. He has no investment within the restaurant
As
itself.
part of this business? Your business put the sign up through him?
Yeah. I was the one that, it's 4 screws. It's a thin melamine, right underneath the roof line, just saying
You know
dinner.
that permits were required for signs on commercial buildings?
We had a sign put up, and it was permitted, and that was Branzini, that's right in front.
And you got a permit for that sign?
Oh, yeah.
Why did you think you didn't need a permit for this sign?
As far as I know, and I'm not going to not take blame or whatever, but it was a melamite sign saying dinner, I don't know, breakfast.
Breakfast, lunch,
and
dinner, full bar.
no Branzini, no. We're not advertising ourselves. It was just an informational sign that's underneath.
When Mr. Berry mentioned the barrier signs,
That had Branzini.
right? Did he make any mention of
No.
the large sign?
No. We would have taken it down at the same time that we took down the other.
This is the sign that you're talking
Yes, sir.
about under tab
Yes, sir.
number 4.
Yes, sir.
Okay.
That's the sign that the violation was issued for.
Yeah, and we never knew that. When Mr. Berry called about and those signs were put up basically about the same time. Mr. Berry called, we took it down within the next couple of days. This sign wasn't installed by giant cranes or anything. It has, screws on it.
Yeah, I understand what kind of sign
So
it is.
we
I
would
saw the
have
pictures.
taken it down immediately.
Okay.
This is just all a big misunderstanding. Gigantic misunderstanding.
May I, Mr. Brooks? I've got some suggestions what to do in the future.
Yeah, I'm not taking suggestions. I can't affect any change here in the city. This is the inappropriate venue for that. If you do have suggestions, you can get with staff and let them know what those might be, or go see the Board of Commissioners at a public meeting. I can't do anything with that.
Because the way it is results in
And you made that point at the last hearing where you were representing Mr. Long. And again, I'm not the legislator in this city. I am an independent third-party arbiter. So this is not that type of public hearing. If you want to make suggestions, I might suggest you go to a Board of Commissioners meeting or get with staff.
Mr. Brooks suggested that I did that, yes.
Do you have anything further in support of your client's case?
Other than the binder and Dick
And I appreciate that. Anything from the city?
No, Your Honor.
Okay, so the city's position is that the policy is that there is no reduction on this one.
They've requested a lien reduction to $10. And it's our position that they knew or should have known that a permit was required to put this sign up, especially when they found out that sign permits were required for the banners, and the banners couldn't meet the criteria. So the fine had accrued until it was removed on March 25th, 2025.
Okay. I am prepared to make my ruling. I I am going to grant a lien reduction. I am not going to grant it to $10. I am not going to change who it is assessed to. That will be between Mr. Long and his tenant and subtenant. And here's my rationalization. Everything I've heard today, and I appreciate, Mr. Melendi, you did a very good job, a very thorough job in representing your client here today. It's hard when you're not in the correct venue to be doing that, and arguments have been waived to present as you are presenting. I do have room to consider the equitable issues here. I found at the hearing, and I continue to find, that notice was proper. You own commercial property in a jurisdiction. I don't care where you go. If you are vacationing in Europe for several years, if you have a second property in South America or Africa or wherever you are, if you are a commercial property owner, you should be responsible for the legal notices that you receive at the addresses that are legally proper in the tax collector's website or the property appraiser's website. That being said, I found at the hearing, and I continue to find, that legally required notice was given to the property owner, which is a valid violator both under the statute and the city's code. Whether it was prudent to notify the tenant, and in this case it would have been a subtenant, it is kind of irrelevant from that perspective. I do find that a notice of the hearing was also posted at the property. I don't have all of the information on the hearing because I had already made my determination whether or not the property owner or the violator was in violation. So I don't have that book of evidence in front of me. Typically, I ask, did you have contact with the property owner? Did you talk to the tenant? Did you hear anything? And I make those considerations within making the determination about what the daily running fine will be. So at the time that I make the determination on the fine, I've considered those types of things. So I'm not reconsidering them. I understand that if it would have been known to the subtenant that the sign was improper, they would have taken it down. They took the other two signs down. What is prudent is if those signs were inappropriate and I had to get a permit for my other sign, what makes me think I don't need a permit for these signs, or ask the question, are these inappropriate? It's not the city's job to go out and monitor everybody's, in all the private property owners or commercial property owners in the city to determine which ones are in violation, which ones are not on any given day at all times. It seems to me that if the property owner wants to put off some of these fines onto the tenant, that needs to be included in a lease. I'm not his attorney. You are. You can advise him of that if you so choose. So while I am going to find that there is a lien reduction based on all that, I am only going to reduce the lien, what the city typically does, which is we're going to reduce it to 10%, so $4,950 plus the administrative fees. If that is in fact the appropriate fine amount. I've got another footnote that says it's 51.5. Mr. Dewar, can you confirm what the actual lien amount is?
$49,000.
$500.
Yes, ma'am.
Okay, so then I will have it reduced to $4,950 plus the $325 in administrative costs. And the reason I'm granting the lien reduction is not just because of the equitable things, but it did take the city in a year from the notice of violation.
Runner, I
to
think you
notice
said
of hearing.
325, it's usually 330, unless I misheard.
No, back in that time period, it wasn't
Oh, that's
330.
why. Okay, thank you.
And that's what's on the application.
Thank you.
So because of the timeliness of bringing this to the hearing, again, I don't have all that information on me because this is not retrying the case. So that's my order. I think I've taken everything into consideration. The administrative order could have been challenged within 30 days. The fine order could have been challenged within 30 days. None of that was done. All those arguments were waived. So here we are. I will get you a written order to that. The reduction needs to be paid within 30 days of my written order. If it does not, or if the payment doesn't clear, then it will go back up to the $49,500. And I have your email address, so I will email you a copy of the order.
So you're reducing the fine down to $4,900, somewhere in that area?
$4,950 plus the $325 in administrative fees.
I don't feel so bad about my fees.
Well, thank you all for your advocacy here today. I appreciate it. That was an interesting one. I hope to never get one like that again. Anything else that we need to go over before I close the hearing today?
No, Madam Special Magistrate.
All right. Then we are scheduled for October 6th. I will see you all then.
Thank you, ma'am.
Thank you.